Hi, Jen.
Hi, good morning. How
Hi,
are
good
you?
morning. Good. How are you?
Good, thanks.
Thank you so much for your patience. All right. Thank you for coming on, Jen. I'm just
Awesome.
going
Thank
to.
you again, Beta, for redoing this presentation. Just a quick little introduction again for our agents. Beta DeLisi is with Stonegate Legal Services. She is a real estate broker and property manager slash paralegal. So she comes from a place of knowing where we operate from and what we need to know to deal with landlords, investors, and tenants, especially right now. So I'm going to let Vita do her presentation, and we'll do a quick Q&A after. And I'm going to let Vita take the room.
Excellent. Thank you so much. Thanks everybody for coming on and listening to best legal practices in owning and operating rental property. This version is called COVID-19 and what it means for realtors, landlords, investors, and tenants. Again, my name is Bita Delisi, and my background lies in real estate. If you already haven't done so, please head over to our social media, Facebook and Instagram, and follow us. I always update our social media pages with changes in the law, any updates. I do quick 1-minute videos. So anything you need to know regarding the landlord and tenancy realm is on our social media pages. If you ever need to get in contact with us, visit us at stonegatelegalservices.ca or give me a call. So let's get started. All right, great. Jennifer gave you a brief introduction about myself, so I won't bore you guys with that. Again, my background lies in real estate. 95% of our business comes from realtors like yourselves because my background lies in real estate. So that's always a great thing. Just a brief little disclaimer, everything we discussed throughout the seminar is for information only and not to be taken as legal advice. If your matter does require legal advice, definitely get in touch with myself or a legal professional. Okay, perfect. So just a couple of preliminary slides we'll go through before we get our feet wet with the COVID-19. A couple of differences between a paralegal and a lawyer. For those of you who don't know, there are just two major differences between a paralegal and a lawyer. Otherwise, they're very similar. So let's go through the similarities first. Paralegals and lawyers are both licensed by the Law Society of Ontario. They're both required to carry errors and omissions insurance. Like realtors, we must also do continuing education credits, and we must abide by rules of conduct. So the first difference between a paralegal and a lawyer is, number one, obviously the fees. Paralegals charge lower fees and lawyers charge higher fees. And the reason for that is because lawyers have far more extensive education than paralegals do. Another major difference is that lawyers can practice law in the lower courts as well as the higher courts. The lower courts are where the paralegals practice law in, such as the Landlord and Tenant Board, the Licensing Appeal Tribunal, the Small Claims Court. Lawyers can practice law in these lower courts as well as law in, family law court or higher criminal court. Those are the courts that paralegals are restricted and cannot practice in. So again, 99% of lawyers, here's another slide, 99% of lawyers do not practice law in the landlord and tenant realm. And the reason for that is because there's simply not enough money in it for them. It's really also not worth a landlord to pay a lawyer $600 to represent them at the board. So that's why they don't, their knowledge and expertise doesn't often lie in the landlord and tenant realm. So the first preliminary slide we're going to talk about is the Residential Tenancies Act, or the RTA, which was previously known and called the Tenant Protection Act. Over the years, it was amended because it did exactly that. It protected the tenants. The Residential Tenancies Act came into effect in January of 31st of 2007. The RTA creates a rental housing system that protects tenants, helps landlords, and promotes investment in Ontario's housing market. This piece of legislation alone affects about 1.4 million tenants in all of Ontario. The Landlord and Tenant Board. Okay, so for those of you who've never had to go to the landlord and tenant board, consider yourselves lucky because the landlord and tenant board is among the few courts or the few boards that is extremely chaotic and extremely unorganized. The landlord and tenant board resolves disputes between landlords and tenants, and either party can apply to the board. Obviously, they have to pay a filing fee and they have to receive a notice of hearing. For those of you who have attended the landlord and tenant board, you will know that the board is laid out similar to a court-like setting. And disputes can be worked out in one of two ways or two ways in some cases. Number one, through mediation, and number two, through adjudication. So let's talk about mediation. I'm a big fan of mediation. I highly recommend it. And I'll tell you why. At mediation, you will sit in a probably a 10 by 10 room with a board certified mediator. This is a third party, an impartial third party that has a license to mediate. So they don't give an opinion, they don't apply the law. They listen to one side, they listen to another side, they ask the relevant questions in hopes of coming to a resolution. Okay, and then if you do agree on an agreement in mediation, then the mediator will put together a mediated agreement. So it is similar to an order. However, you do have influence or control on the outcome of the matter. That's why mediation is fantastic because it gives you the option, it gives both sides the option to, to choose what they want to do and be happy at the same time by giving them an influence on the outcome. Now, not everything that you discuss in mediation will make both sides happy. So sometimes what happens in mediation has to stay in mediation because you don't agree to a resolution. So what happens next? You're forced to go in front of the adjudicator. So you have to go back into the hearing room, wait for your matter to be called, and then let the adjudicator decide. You got to keep in mind when you go back to the hearing room, the adjudicator is also supposed to be a third party impartial member. However, they have stacks and stacks of files that they're probably deciding on, I don't know, anywhere from 60 to 70 matters in the matter of an hour and a half to 2 hours. So they don't really have, they don't really care about the evidence, or they don't care about who said what or your emotional ties to your matter. All they care about is hearing one side, hearing the other side, and making a decision and sending out their decision in the mail. That's all they do. That's why mediation is such a great option. Okay, so we're going to get our feet wet a little bit. Let's start talking about the concerns surrounding COVID-19. Our office has been flooded with concerns from realtors, landlords, and investors regarding, their matter around what's been going on with the COVID-19 pandemic. These are the top 6 concerns that they have, and we're going to address all of them. So let's get cracking. So the top question I'm getting asked loads of times is, can tenants stop paying rent during the COVID-19 pandemic? Okay, so from this slide on, I may sound a little insensitive, so just bear with me. And the reason I may sound insensitive is because the law doesn't have a heart, so it has no emotional ties. It is what it is, and that's it. So to answer this question, no, tenants cannot stop paying rent during this COVID-19 pandemic. The Residential Tenancies Act says that rent is due and payable on or before the first of the month. This means that rent is considered late if it's not paid by the date that it's due. If a tenant does not pay rent by the date that it's due, the landlord has the right to give the tenant an N4. An N4 is a legal form. It's called Notice to Terminate Tenancy for Non-Payment of Rent. The landlord can issue this notice the day after the rent was due. So what is this notice? So this notice gives the tenant an option to pay all the arrears they owe in full or move out of the rental unit within 14 days. Okay, so 14 days, not business days, 14 calendar days. After the 14 calendar days, if the tenant does not pay in full and if they are still in possession of the rental unit, then the landlord has the right to apply to the board for a hearing date. Okay, so they take your N4 and they apply to the board for a hearing date. They don't need to they don't need to send you a copy of the hearing date notice. That will be mailed out from the board. This is what the N4 notice to terminate tenancy for non-payment of rent looks like, okay? Right now, landlords have the right to serve this notice and file it with the board after the 14-day period. So the top part, as you can see, is the first page of the notice. The bottom part, as you can see, is the second page of the notice. Now, before I go through, the issues with this notice, I can't stress this enough, okay, guys? Realtors cannot fill out or serve this notice or any notice that's linked to the landlord and tenant board. You guys can't do that, and I'll tell you why. Anytime a realtor does this, as a favor for their client, they're providing a legal service, and they're not licensed. They're not licensed as a paralegal or a lawyer to provide a legal service, which means if something happens down the line and you get in some sort of trouble, your insurance, your errors and omissions insurance will not protect you. In fact, it can go a step further. Your brokerage can be held liable as well. And we all know you don't want to get yourself or the brokerage in any trouble. So, what can happen? So if you are filling this out and serving it on to the tenant as a favor to your client, and if you do make a mistake, so if there is an error in the name, where you forget the unit or you forget the postal code, or your figure is off by 15 cents or 25 cents, or you didn't count the dates properly, all these taken into consideration at the board, your hearing will get dismissed. So prior to the COVID-19, we were waiting, in order to get a hearing date, you would probably wait about 5 to 6 months. Okay, now, as of March 16th, all in-person hearings that have an eviction linked to them, which includes the N4, these are all in-person hearings are scheduled to a future date. So these notices and these hearings are all on hold. What that means is when the board reopens, we're assuming that it may actually bump up to waiting 9 to 12 months before you get in front of the board. So what does that mean for realtors? So that means if there's an error in the notice, and if your client has a tenant who's not paying rent, if they haven't paid for 9 months, 10 months, 11 months, that can be thousands of dollars in arrears, thousands of dollars of lost revenue for your client. Are you going to risk having that hearing date dismissed? Is it worth it, waiting 9 months and then having to do it again? Not at all. So please don't put pen to paper and serve any notice. So let's talk about the last month's rent, because this is the deposit that the landlord has in hand. And this is the question that I'm getting tons of uproar around, because this is the money that's already, the landlord already has it. And the tenant is always asking, tenant would always ask, can the last month's rent be used to cover the month that the tenant cannot pay? Okay, so the answer to this question is a hardcore no. Okay, so let's discuss the last month's rent. The landlord can collect a rent deposit from a new tenant on or before the start of a new tenancy. That deposit cannot be for more than 1 month's rent. And that deposit cannot be used for anything else except for the last month's rent. So any other forms of deposit, with the exception of a key deposit, which is which is outlined in the Ontario Standard Lease, any other deposits such as a pet deposit, a damage deposit, a light bulb deposit, all these deposits are seen as illegal deposits. So a landlord cannot ask for any other deposit other than a last month's rent deposit. The reason why I'm so against landlords eating this money up before the tenant uses it for the last month is because if you have a tenant that's very savvy and they know how to work around the law, come time for them to leave, they can actually skip out on paying the last month's rent and the month before the last month's rent. So that's what you want to avoid. You want to use the last month's rent for the last month. Okay, so again, many questions surrounding notices. I'm going to provide a little bit of clarity. Can landlords still serve notices N4, N5, N6, N8, N12, N13 to tenants. So the notices that I've listed up there are notices that have evictions attached to them if the tenant doesn't leave by the termination date, which means you'd have to go file with the board and you have to wait for a hearing date and your matter has to be heard at the board. Currently, all in-person hearings are on hold and they're going to be rescheduled to a future date effective March 16th. So the answer to this question, yes, the landlord still has the right to serve notices in order to commence a paper trail. And if you haven't received your rent on April 1st, you want to make sure that you do accommodate the tenant. By accommodating the tenant, and we're going to talk about relief options later on in the presentation, as a landlord, you still have the right to commence and serve them with an N4. And I'll tell you why. Keep in mind, when the board opens in about 3 or 4 months, the amount of landlords that are going to, run to the board and file their notices is going to be a huge amount of landlords. You want to make sure that you're among the very, very first landlords who get to the board first, because you don't want to wait 11 or 12 months for a hearing date. So the quicker you are to serving an N4, the better it will be. Eventually, it's inevitable that the board will reopen, and those tenants who are in arrears will have a high possibility of being evicted. Okay, so another question is, if the tenant, and we don't have it here, but I'm gonna provide a little bit of clarity here. If the tenant doesn't pay for April and we serve an N4, and then the tenant doesn't pay for May, do we have to serve another N4? And the answer to that question is no. If you've served an N4 on April 2nd or April 3rd, and you filed it on April 15 or 16 with the board, there's no need for you to resubmit or reserve another N4 to the tenant. And the reason for that is because when you go to the board on the day of your hearing, you're going to fill out an update sheet and you're going to list all the months and all the arrears that the tenant owes you. Okay, so only one N4 is suffice. Again, I've mentioned this. What is going on with in-person hearings? Again, effective March 16, all in-person hearings with an eviction attached to them, which is what I've listed on top, the N4, 5, 6, 8, 12, and 13. Those are the hearings that have an eviction attached to them, and those are the hearing dates that are going to be rescheduled to a future date. Now, alternative hearing options such as written and telephone hearings are being considered, however, only for applications that do not have an eviction attached to them. So what are these applications? Typically applications that are from the tenant, which is a T2 tenants rights application or a T6 maintenance and repair application. These are issues that can be worked out in mediation, whether it's over the phone, is a written hearing, or it's a video conference hearing. So those are the ones that are likely going to have alternative hearings that are not in person. Mortgage deferrals. There needs to be a lot of clarity around mortgage deferrals. So I am not a mortgage broker. So any questions that you have regarding mortgage deferrals, I would direct them to your mortgage professional. However, to provide a little bit of clarity, because a lot of tenants are saying, if the landlord's mortgage is being deferred, why do we have to pay the rent? Well, because a deferral is not a forgiveness of that mortgage payment. A deferral is to postpone that payment to a future date. In order for the landlord to get approved for a deferral, they have to go through a qualification process. And right now, there's an unclear criteria linked to that qualification process. I had a client that phoned one of the top banks in order to inquire about a deferral, and she was on hold for up to 6 hours. So if you are going to be calling in to inquire about a mortgage deferral, just remember you to set a extensive amount of time aside, because you don't know when you'll be able to speak to a representative. New mortgages. So by new mortgages, I mean mortgages that they're less than a year. They do not qualify for a deferral, unfortunately. Again, in order for you to get approved for a deferral, it's like going and applying for a mortgage again. So they'll have to pull a credit check, they'll have to do a credit application to qualify. There's a whole qualification process. Some rental properties actually do not qualify for a deferral. So if those are the tenants that are holding back rent, that landlord is going to if- feel it, because they're going to have to come up with the money to carry the ongoing expenses out of their own pocket. What CMHC is doing, CMHC is actually supporting lenders in allowing deferral of mortgage payments for up to 6 months, which is fantastic. However, if you go on a mortgage deferral, if you Google mortgage deferral calculator, you'll notice that there's a cap on how much money or how much your mortgage payment can be deferred, and usually that cap for most lenders is $5,000. So if you input that $5,000 or the maximum borrowing cost, you'll be able to see the cost of borrowing. So the interest rate on borrowing the $5,000. And often these deferrals can result in double payments when they become due. So you actually, as a landlord or an investor, it's best to see if it's actually even worth it for you to defer your mortgage. So let's talk about the keep your rent movement for April 1st. So for those of you who have properties downtown or have clients who own rental properties downtown, you may have heard about this keep your rent movement April 1st. The Parkdale community, which is a lower income community located in downtown Toronto, these tenants have all come together. They formed a tenants association, and they are encouraging other tenants to hold back the rent for April 1st. And what they're saying is that, the landlord doesn't need the money, but the tenants do. So just a reminder, we're all going through hardships during this uncertain time together. It's not just the tenants. And you may have seen these ads around floating over social media if you do belong to landlord and tenant groups. Again, the Parkdale community, keep your rent April 1st. So most tenants feel that, we don't have any relief options. That's why we're going to hold our rent. And that's not true. There are relief options available to tenants. I've listed the top 3 relief options. We're going to go through them, and then I will make my recommendation on which one I think is the best one. So let's talk about payment plans. Payment plans are a great option. However, there's a difference between a payment plan that's put together by the landlord and tenant board and a payment plan that's put together by the landlord and tenant. The payment plan that's put together by the landlord and tenant board usually comes with an enforcement. And what that means is if that tenant defaults in the payment plan, or if that tenant breaches the payment plan agreement, the landlord can go to the board and apply to the board for an enforcement to enforce an eviction. Whereas the payment plan that's put together by the landlord and tenant, if it's not worded properly, the landlord come time down the road, the landlord may actually realize, that they have permanently lowered what was lawful rent. Also, the other difference between a payment plan put together by a landlord and tenant is that sometimes if the tenant breaches that payment plan, there's no way that the landlord can go after them. That's why it's so important that the landlords still continue to serve the N4 and file it with the board. Also, politicians are asking landlords to give free months and rent discounts, but they're not doing anything to protect the landlord. It's like a catch-22. So again, payment plans are great, but if they're not worded clearly, if they're not worded properly, the landlord may realize that they have actually permanently lowered lawful rent, which is something we don't want to do. The next relief option number 2, is the rent bank. The rent bank is fantastic. 99% of people have never heard about a rent bank. And the rent bank does exactly what it's called. It's a bank that tenants can turn to if they're facing, hardship. So the rent bank, and I've listed the Toronto rent bank number because that's the most popular one. But if the rental property is located in different municipalities, um, just one second. I think somebody woke up. Just one second. Ooh. All right. Okay, perfect. So getting back to the rent bank. Again, so if the rental property is located outside of Toronto, for example, in York Region or in Durham or in Peel, all you'd have to really do is Google York Region Rent Bank and it will pop up. So the rent bank provides limited interest-free loans to seniors, individuals, families, basically anyone facing a hardship or eviction for rental arrears. It's great because tenants who have filed bankruptcy or they have bruised credit or they've consolidated their loans, they'll also qualify. So the qualification process is lenient. Another thing that's great about the rent bank is that the maximum loan is that they'll lend out is 2 months rent, which is fantastic because that's 2 months of relief from the tenant. The rent bank also provides a first and last month's rent deposit if a tenant wants to move from their existing rental unit to a more affordable or stable housing rental unit. I highly, highly recommend the rent bank, and that the major benefit to the rent bank is that the tenant doesn't need to come up with a payment plan and hope with the landlord, and the landlord doesn't have to hope that the tenant will carry out that payment plan because the rent bank will take 5 to 7 days to issue payment to the landlord, and then they'll come up with a more suitable payment plan between the rent bank and the tenant. So that's why it's so great. The third option is the credit card option for rent payments. So this is my AirPod case. So this is the product I'm referring to is actually called Square. You would have to Google it, and it looks like this. It actually looks like your AirPod case. It's got a little port like that, and that port will hook up to your cell phone. And then once it hooks up to the cell phone, if you do online banking, it will hook up to your account, obviously. And that the Square has a little, I guess, a little swipe thing up here, which you can manually swipe their credit card, which is fantastic. Now, provided that they have money on the credit card, the landlord will get paid instantly. However, if the landlord isn't able to go to the tenant's unit and grab their credit card and do a swipe, they can manually input the credit card number. Another great feature about the credit card option is that even though it comes up with a higher interest rate that the tenant has to pay, again, there's no payment plan option that the tenant and landlord need to put together. So I highly, highly recommend the rent bank because the landlord gets paid instantly. My second recommendation is the credit card because, again, the landlord gets paid instantly. And last but not least, the payment plan. Again, the only downfall with the payment plan is that there's no way for the landlord to enforce it without having to go to the board. So tenants, please don't hold back your rent. So rent is still due and payable. The objective of these relief options is to keep the tenant in the property. It's not to kick the tenant out. This is not the objective. We don't want people on the street. Okay, that's why these relief options are so important. So we've come to the conclusion of our presentation. Thank you for being patient. Again, if you already haven't done so, follow us on social media, but I am going to open up the floor for questions.
And I'm the floor. So I just wanted to clarify a couple of small things. When the landlord is filing that and any of those end notices online, can they pull those notices if the tenant has brought all payments up to date before the LTB comes back for hearings?
They can. So the N4 has a voidable period. So it says we're going to discuss the N4. So the N4 has a 14-day period. The tenant can void that notice by paying within 14 days.
Okay.
If the tenant pays after the 14 days, if and the landlord has already filed with the board, but the tenant is all caught up with all the arrears that they owe moving forward, then the landlord can always withdraw their notice of hearing.
Okay. Um, Notices. And oh, we talked about deposits and the illegal deposits. Um, one of the questions that we had on our previous call was, um, with a key deposit, you're only allowed to charge for the amount of the actual replacement of the key itself. You cannot, and nothing else. So if it costs if it's a specific special key that requires a $250 replacement key, that is the cost that you can replace. If it's a $1.50 key, that is the only fee you can charge. If you need to replace a lock set because a tenant has failed to return keys, can you charge the tenant for that?
Not for replacing the lock. A
Okay.
key deposit is just that. It's the cost for a key. It's not a lock deposit. So if the landlord has to replace the lock, then that's out of pocket expenses for the landlord. Usually, if you hire a locksmith, they can rekey that lock without actually having to replace that lock.
Right. Um, the rent bank, well, we'll include a link to all of the local rent banks for us. And that is an interest-free loan
It's
for tenants.
very low or no interest. However, it is a loan. It's not gifted funds. Okay, it's
Okay.
not free money. It is a loan.
Okay. But any tenant who is worried about the fact that they've claimed bankruptcy in the past or anything will still qualify for the loan,
That's correct.
essentially.
That's
Okay.
correct.
What I know that we had a few questions. Um, so if an agreement is come to during mediation and one of the parties reneges on that does would it be pushed towards adjudication that much faster because there was a previous mediation agreement?
So if you have a mediation agreement, two things can happen. And depending on what's in that agreement, the landlord can take that agreement and file with the sheriff immediately. Or the if it says that the landlord has to come back to the board, the landlord has to come back and fill out an L4B notice, to L4B application to the board, and request for the board to issue an order to evict.
Wow.
Yeah, so it depends on what is worded in your mediated agreement from the beginning.
Okay, so it's pretty clear, black and white, in how the process works from there. I think one of the other questions that we had was, oh, you know what? A really good thing to bring up is who pays for what. So I know that the tenants can usually file any of their issues for free. When is it still going to be costing the landlord to file these notices online right now?
It is, and I hate to be the bearer of bad news, but those filing fees are gone up.
Oh my
Uh,
God.
they have, but it is a misconception. The tenants cannot file for free. Low income tenants can request the fee to be waived. Okay, they have to provide obviously their their notice of tax assessment. However, there is a cost for filing for the tenant.
Oh, good. That's, I know a lot of landlords were concerned about that in the past.
Obviously, it's not $200, but I mean,
No.
it's probably around 45 to $50.
All right. So when you talked about setting up payment plans, because I know that some landlords are trying to work with their tenants, um, do you recommend that the landlord have a payment plan drafted by somebody like yourself to ensure that they're not opening up any loopholes?
Absolutely.
Okay.
Absolutely. And I'll tell you, some people want to save the money because they think Google will help them. However, those are the people that are jumping over the dollar to pick up the penny.
Right.
And then those are the people that are going to realize down the road that they've actually lowered lawful rent, which
Okay.
is, it's great for the tenant, but not for the landlord.
Okay. So I think that wraps up all of our additional questions. And if anybody has any questions outside of what we've provided here, Please make sure that you reach out to Beta directly, and she's more than happy to respond very, very quickly. And I thank you again for taking the time to go back through this presentation with me and answering some of these questions. And it's been great to catch up and learn a lot more about what's going on, especially during these crazy times.
Thank you. I know we're going to get through this, but if anybody has any questions, again, feel free to reach out. I'm always here.
Awesome. Thank you again, Beta, and we'll catch up soon.
Sounds like a plan. Bye
All
for
right.
now.
Bye.
Mm.